RA 11235 for the Motorcycle Prevention Act. This law penalizes drivers who use motorcycle to commit crime. That's why the use of larger motorcycle plates is being implemented compared to the one used before, so that easily to read and identify the details. And the parts of the plate's bigger encoded number are brighter. Remember, the first registration of a motorcycle should be done by the owner of the motorcycle in the LTO. If the driver gives the dealer the authority to do the registration, this can be done but only within 5 days after the sales invoke of Certificate of Tax reported or CSR is issued. Plate should be distributed by the LTO. This plate is bigger, easily to read and color coded. The metal number plate is placed the back of motorcycle, what we call decal. Is number plate placed in the front. The motorcycle number plate is readable from the distance at least 15 meters away. All motorcycles should have rear plate lights. We may ask, do the new plate have the same color? The answer is no. The motorcycle plates are color-coded to easier for enforcement agency to identify them. Private motorcycle is used white background with alphanumeric character. Here is also called color stripe placement for the National Capital Region or NCR and for the other region. The whole plate remains white, while the other region have designated color stripes. Notice it is placed in the top. What violation can you get if you fail to follow RA 11235? First, is the motorcycle is not registered or sale of the owner reported on the LTO in 5 days after receiving CSR, they will be fined 20,000 up to 50,000 pesos. If the driver used the motorcycle without plate number, they can be fined 50,000 up to 100,000 or what we call prison correctional. It is possible the penalty is given. For enforcer not surrender the plate of authority 1 day after make apprehension and confiscation, they also given the penalty prison correctional. Please take note of the following violation and penalties. If the motorcycle used for commission of the crime in grave felonies under the revised penal code. Owner, driver, and back rider, reclusion temporal 12 years and 1 day to 20 years. For example, slight physical injuries, theft, alteration of boundary marks under the revised penal code. The motorcycle used the commission of the crime, the driver will receive the maximum penalty of the relevant crime or offense. To be better, avoid committing violation against the law, so don't get penalties or fines. Public Act 10930, an act rationalizing and strengthening the policy regarding driver's license by extending the validity period of driver's license and penalizing acts in violation of its issuance and application. This act provides amendment to Section 23 of RA 4136 for the Land Transportation and Traffic Code. The LTO should promulgate prerequisites and guidelines before the grant of driver's license to ensure that these are issued only in deserving applicant sufficient driving skills and knowledge on road safety and proper road courtesy. Penalty include a fine in the amount of 20,000 pesos imposed on a driver's license applicant found to have committed any of the following acts. Number 1. Willful mispresentation with respect to material information in one application. Number 2. Connivance with the officer in interest, conduct of examination or issuance of license. Number 3. Falsification of document or number 4. Cheating during examination. Any or all of the acts above mentioned should be punished whether a license was granted by a reason of such mispresentation, connivance, falsification, or cheating.
Good day, sir. My name is Floyd Welt SOI based Grand Trivabo. So today, I'm going to discuss the Republic Act 10913, the Anti-Destructive Driving Act. Anti-Destructive Driving Act It is a law prohibiting a person driving a motor vehicle from holding and using mobile communications devices and electronic entertainment gadgets. Its legislation implemented in various countries to discourage activities that divert a driver attention from the road. Penalty usually involves fines or other legal consequences to promote safer driving practice. For example of Anti-Distracted Driving Act are texting, making phone calls without a hands-free device, using social media or watching videos while driving, and also eating foods and drinking beverage while driving, also considered as a distraction depending on the extent it diverts attention from the road. And the Republic Act No. of 109/16, Road Speed Limiter Act of 2016, it is hereby declared the policy of a state involves the installation of devices in vehicles to restrict their maximum speed. This legislation aims to enhance road safety by preventing vehicles from exceeding a certain speed limit. The speed limiter device controls the engine's power to maintain speed limits with a set limit, promoting safer driving practice and reducing the risk of accidents by accused excessive speed. Countries implement their visions of this act to regulate and improve road safety standards. For example, public transportation. Some countries enforce speed limiters in public transport vehicles to ensure passenger safety. Buses and other vehicles used for public transportation may have speed limiting device to maintain safe speeds.
Good day, everyone. I am Ikot Mayneth of BIS Criminology 3rd Year Section Bravo. I'm here to give further information about the Republic Act number 5448 and 8749. Republic Act number 5448, it is an act imposing a tax on privately owned passenger automobiles, motorcycles, and scooters, and a science stamp tax to constitute a special science fund defining the programs, projects, and activities of science agencies to be financed therefrom and for other purposes. Section 1. The creation of Special Science Fund. There is hereby created a Special Science Fund, hereafter referred to as the Fund, to be constituted from the proceeds of the taxes imposed in Sections 3 and 4 of this Act to promote scientific and technological research and development, foster invention, and utilize scientific knowledge as an effective instrument for the promotion of national progress. Section 3. The imposition of additional tax on privately owned passenger automobiles, motorcycles, and scooters. An additional tax is hereby imposed on every new or current model of privately owned passenger automobile, motorcycle, and scooter to be paid by the owner thereof in the amount based on the respective shipping or factory weight of private passenger automobiles as indicated in the following schedule. 1,000 kilos or less is 35 pesos, 1,001 kilos to 1,500 kilos is 100 pesos, 1,501 kilos to 2,000 kilos is 250 pesos, 2,001 kilos and above is 450 pesos. The owner of a private motorcycle and scooter shall pay a fixed additional tax to 15 pesos, and that of a jeep is 20 pesos. Section 4. Imposition of additional stamp taxes. In addition to the documentary stamp taxes imposed under Sections 211 to 235 of Commonwealth Act numbered 466 as amended otherwise known as the National Internal Revenue Code, there are hereby imposed science stamp taxes equal to 100% thereof, except that in addition to the documentary stamp taxes on tax clearance certificates under Section 225 thereof, the science stamp taxes shall be as follows: 50 pesos on each certificate for a first class passenger, 30 pesos on each certificate for a second or tourist class passenger, and 5 pesos for a third class or steerage passenger. Provided, however, that no science tax shall be imposed on each certificate issued by a notary public or by any person authorized to administer oath. This act states the necessity of the owner of passenger vehicles to pay tax and was created to have fundings on science programs, projects, and activities. Republic Act number 8749. This act was approved on June 23, 1999. An act providing for a comprehensive air pollution and control policy and for other purposes. Section 1, the short title, this act shall be known as the Philippine Clean Air Act of 1999. Section 2, the Declaration of Principles. The state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. The state recognizes that the responsibility of cleaning the habitat and environment is primarily area-based. The state also recognizes the principle that polluters must pay. Finally, the state recognizes that a clean and healthy environment is for the good of all and should therefore be the concern of all. Fines and penalties. The violation of standards for stationary sources. For actual exceedance of any pollution or air quality standards under this Act or its rules and regulations, the Department, through the Pollution Adjudication Board or the PAB, shall impose a fine of not more than 100,000 pesos for every day of violation against the owner or operator of a stationary source until such time that the standards have been complied with. The fines herein prescribed shall be increased by at least 10% of every 3 years to compensate for inflation and to maintain the deterrent function of such fines. Violation of standards for motor vehicles. No motor vehicle shall be registered with a DOTC unless it meets the emission standards set by the Department as provided in Section 21 hereof. In addition, the driver and operator of the apprehended vehicle shall undergo a seminar on pollution control management conducted by the DOTC and shall also suffer the following penalties. First offense, a fine not to exceed 2,000 pesos. Second offense, a fine not less than 2,000 pesos and not to exceed 4,000 pesos. And third offense, 1 year suspension of the motor vehicle registration or the MVR and a fine of not less than 4,000 pesos and not more than 6,000 pesos. Any violation of the provisions of Section 21, Paragraph D with regard to National Inspection and Maintenance Program, including technicians and facility compliance, shall penalize with a fine of not more than 30,000 pesos or cancellation of license of both the technician and the center or both as determined by the DTI. So this act was primarily created to promote and protect the global environment to attain sustainable development while recognizing the primary responsibility of local government units to deal with environmental problems. That's all. Thank you.
Republic Act 4136, otherwise known as the Land Transportation and Traffic Code. This is the basic law regulating land transportation in the Philippines, which means the law laid the groundwork for almost all of the traffic, including the creations of the LTO, Land Transportation Office. Republic Act 4136, it is required both the registrations of all the motor vehicles and the applications of all the driver for either a professional or non-professional license. Republic Act 10883, or otherwise known as the New Anti-Carnapping Act of 2016, is a law which punishes carnapping in the Philippines. For purposes of knowing what carnapping is, one must be able to know what motor vehicle is. In the first place, as defined under the law, motor vehicles refers to any vehicle propelled by power other than muscular power using the public highways. So Republic Act 10883 punishes the crime of carnapping, which refers to taking with intent to gain of a motor vehicle belongings to another without the latter consent, or by means of violence against or intimidations of a person, or using force upon things. So there are 5 elements of carnapping. So number 1 is actual taking of vehicle. The offender has an intent to gain. The owner's consent is lacking. The means employed is involved violence, intimidations of force upon things. The penalty of carnapping, rather for carnapping, just like any other serious crime of any person who is found guilty of the carnapping shall, regardless of the value of the motor vehicle taken, be punished by the imprisonment. When the carnapping is committed without violence against or intimidations of the person or force upon things, the imprisonment shall be for a period not less than 20 years and 1 day, but not more than 30 years. When the carnapping is committed by means or violence against or intimidations of the person or force upon things, the imprisonment shall be for a period not less than 30 years and 1 day, but not more than 40 years. Take note that when the owner, driver, or occupant of the carnap motor vehicle is killed or raped in the commissions of the carnapping, the concealment of carnapping shall also be punishable under the new law. Any person guilty of concealment of carnapping shall be in imprisonment for 6 years up to 12 years.
Good day everyone, my name is Saymar Matugas. So today, we will tackle these two Republic Act, which is RA 11229 and RA 10666. Child Safety in Motor Vehicle Act, otherwise known as RA 11229. It is a system designed to be capable of accommodating a child occupant in a sitting or supine position and is used to diminish the risk of injury to the child. No 12 years old and below of age shall be allowed to sit in the front of a motor vehicle unless they met the height requirements set forth in Section 4. The child is at least 150 cm or 59 inches tall to be seated in running motor vehicle with a standard child restraint system or a child seat. The second one is the Children's Safety on Motorcycle Act or the Republic Act 10666. The law is the manifestation of the government's attempt to offer protection to children on the road. It prohibits any person from driving a motorcycle on public roads with a child on board and offers a clear guidelines for children's passenger on motorcycle. Section 4 Prohibition. It shall be unlawful for any person to drive a two-wheeled motorcycle with a child on board on public roads, while there are exemptions. The rules apply to every child as long as they are below the age of 18. Violation of the law may result in hefty fines or even suspension and revocation of driver's license. In worst cases, or in case of injuries and accidental death, the driver may also be sent to jail. That's all for today. Thank you.
Good day everyone. I am here to discuss about RA 8750 and RA 7924. The Republic Act 8750 mandates the installation and use adult seat belts in front and rear seats of private motor vehicle. 54% of all injuries in the Philippines occur in the streets each day. In the country, about 65 individuals die and 60 others are injured due to a vehicular accident. An act amending Section 12 of Republic Act number 8750, otherwise known as an act requiring the mandatory compliance by motorists and private vehicles and public vehicles to use seatbelt devices and requiring vehicle manufacturers to install seatbelt devices under manufactured vehicle. And RA 7924, otherwise known as an act creating the Metropolitan Manila Development Authority, an act that defining its power and function, providing funds, therefore, and other purposes. Amending RA number 7924, creating the Metropolitan Manila.
Good day everyone, my name is Dilmar Lobador, base crime from 3B. I'm here in front of you to discuss about Republic Act 154, an act mandating all motorcycle riders to wear standard protective motorcycle helmets and while driving and providing penalties therefore. The law mandates all motorcycle riders, drivers, and backride to wear standard protective motorcycle helmets while driving, whether long or short drives in any types of road and highways. At all times, standard protective motorcycle helmets are appropriate types of helmets for motorcycle riders that comply with specification issued by the Department of Trade and Industry (DTI). Types of helmet: full face, open face, three-port, half head. Exempted are drivers of motorcycles. Any person caught not wearing the standard protective motorcycle helmet in violation of this act shall be punished with a fine that includes: first offense, 1,000 pesos; second offense, 3,000 pesos; third offense, 5,000 pesos; fourth and succeeding 10,000 pesos plus confiscation of the driver license. Next, Republic Act 10586, an act penalizing person driving under the influence of alcohol, dangerous drugs, and similar substance and for other purpose. The law states that it shall be unlawful for any person to drive motor vehicle while under the influence of alcohol, dangerous drugs, and or other similar substance. Test to be done to determine drives intoxication and use of dangerous drugs includes the alcohol breath analyzer (EVA) test and mandatory drug testing if a driver is found to have been driving a motor vehicle while under the influence of alcohol, dangerous drugs, and or other similar substance. Penalties shall be includes the following.
PD 96 that it shall be unlawful for the owner or possessor of any vehicle to use or attach to his vehicle any siren, bell, horn, whistle, or other similar gadgets that produce exceptionally loud or startling sound, including dome lights, blinkers, and other similar signaling or flashing device. What is the PD 96 exemption? The Presidential Decree Number 96 penalizes the unlawful use of sirens, blinker, dome lights, and other similar emergency device which may be used only by ambulance, policemen, firemen officer, and land transportation franchise and regulatory board as well as by member of National Bureau of Investigation. Erwin Teng, Parteles Mabuhay, said, Presidential Decree 96 issued on January 13, 1973 by late President Ferdinand Marcos state that only the Armed Forces of the Philippines or AFP, the Police Authority or Philippine National Police, the National Bureau of Investigation or NBI, the Fire Department and Hospital. The second one are RA 10642 Philippine Lemon Law. This is why the RA 10642, otherwise known as the Philippine Lemon Law, exists to give consumer full protection when it comes to their rights against business or trade practice that are deceptive, unfair, and detrimental to consumer and the public interest. What vehicles are the covers by penal law? The Lemon Law further limits its covers to only common four-wheel road vehicles such as car, pickups, vans, sport utility vehicles, and Asian utility vehicles, It especially includes motorcycles, delivery trucks, dump trucks, buses, low mowers, and heavy equipment and farm equipment. When was the Lemon Law implemented in the Philippines? 10642, otherwise known as the Philippine Lemon Law of 2013, was signed into on July 15, 2014 to provide protections to buyers who acquire vehicles that are defective or non-conforming to the manufacturer's or the distributor standard of quality and specialization.